All right. Good morning, everyone. We are now on the record and video streaming. I'm calling this evidentiary hearing to order. My name is Andrew French. I'm chair of the Kansas Corporation Commission, serving as presiding officer for this hearing, and I'm joined by my fellow commissioner, Annie Keither. This is a docket number 25 CONS 3342 CWLE, captioned in the matter of the application of Darrah Oil Company, L.L.C. for a well location exception for its Drummond number 1 well to be located in the south half of the southeast quarter of section 26 Township 33 South, range 5 East, Cowley County, Kansas. We are going to begin today's hearing with the entries of appearance. We will start with the operator, Darrah Oil.
Well, thank you, Chair French. This is John Schlatter of the Morris Lang Law Firm on behalf of the applicant, Darrah Oil Company, L.L.C.
Good morning, Mr. Schlatter. We will now move to counsel for protesters, Brown et al.
Thomas Rhodes on behalf of the protesters, J.O. Brown and Patty Brown et al.
All right. Good morning, Mr. Rhodes. And finally, we turn to counsel for commission staff.
Good morning, Chair French. Kelsey Marsh on behalf of commission staff and the public generally.
All right. Good morning, Mr. Marsh. We will now turn to notice of this hearing. Does staff have a recommendation regarding notice?
Yes, on September 15th, the presiding officer provided notice of this hearing in this matter by filing an order setting evidentiary hearing, wherein the evidentiary hearing was scheduled for Thursday, October 16th, 2025, beginning at 9:00 a.m. via the Zoom video conferencing platform. The presiding officer's order was properly served on the parties who are all in attendance today. Additionally, the operator provided notice of this hearing through publication in the Wichita Eagle and Cowley Courier Traveler newspapers. Staff recommends the commission find that notice is proper and that it has the jurisdiction to hear this matter at this time and place.
All right. With that, are there any objections to notice? Hearing none, and based on staff's recommendation, I will find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. Let's move to a few preliminary matters. First, I'll start with mine, and then I'll give the parties an opportunity if they have anything preliminary to take up. Just on my end, I just want to discuss the procedure. But before we go there, want to remind everybody that we are conducting this over Zoom, and sometimes things can go wrong. So if any party encounters a technical issue, please just ask to go off the record, and then we can recess, resolve the technical issue, and then we'll go back on the record. Next, because we're on Zoom, witnesses are asked to keep their microphones off or muted when they're not scheduled to talk. And if everyone would mute their cell phones in their office, other electronic devices, that would be appreciated. Third, so the parties are aware, if the commission needs to consult among ourselves for something like an evidentiary ruling, we'll go off the record and we will enter, the commissioners will enter into what's called a Zoom breakout room to discuss, and then we'll return and go back on the record. And fourth, finally, be very careful to identify exactly what you're referring to when you're discussing pre-filed testimony or exhibits. We should all have copies of everything that the parties wish to discuss, but if you would be very careful to just identify it so that we are all able to follow along, since we're conducting this virtually, that identification really helps. So with that, before we go to the procedure for the hearing, is there any other preliminary matter that the parties wish to take up at this time? All right, hearing none. Regarding the procedure for the hearing, it's going to be our standard procedure. Parties will be typically allowed to make opening statements. We are planning for that. After opening statements, we will turn to the examination of the witnesses. After direct examination of each witness, there will be an opportunity for cross-examination, commissioner questions, and redirect. Anything further beyond redirect would simply be at the discretion of the commission. Following witness examination, we will allow for closing statements, and we will arrange for filing of post-hearing briefs and the scope of those briefs if necessary, and then we will conclude the hearing. So with that, as I just mentioned, we will turn to opening statements first, and I believe we will begin with the operator. And so, Mr. Schlatter, if you'd like to begin with your statement.
Thank you, Chair French, Commissioner Keither. As I'm sure you're aware, Darrah Oil seeks to drill its Drummond number one well at a location inside the 330-foot setback from the south lease line. Darrah Oil first sought to obtain the consent of the mineral owners on either side of the road or lease line to form a voluntary 10-acre unit. The protester, however, would not allow such a unit, as his own testimony indicates. Accordingly, Darrah Oil's only option to drill the Drummond number one well at the most favorable location to prevent waste was to file this application seeking the well location exception. It's not disputed that Darrah Oil's application satisfies all of the requirements to be granted a well location exception under Commission regulations, specifically KAR 823-108. Mr. Lease and Mr. Eastis, who are the only two witnesses you will hear from today qualified to provide opinions in the field of petroleum geology, will testify that the drilling of the Drummond number one well is necessary to prevent waste, and indeed Commission staff recommends granting this application. KAR 823-108 is clear that a well location exception can be granted by this commission if necessary to prevent waste. It's also undisputed that the Drummond number one well should be granted a full production allowable, as the evidence presented by Mr. Lease will show that is also necessary to prevent waste. I would note that no evidence was offered by protester through its pre-filed testimony concerning the technical aspects of this application, specifically why granting the application would cause waste, and you will probably not hear any today. Rather, the entire basis of the protest is rooted in inequity. Protester has sought to utilize this forum to leverage away the valid leasehold rights of Darrah Oil and to extort a better deal for himself to the direct detriment of his neighbor across the road. We believe this demand is improper and should be disregarded. For these reasons, Darrah Oil requests its application be granted, that an exception to the statewide minimum setback be allowed for the drilling of the Drummond number one well at its proposed location, and that the well be afforded a full production allowable.
All right, thank you, Mr. Schlatter. Now we will turn to Mr. Rhodes for the protesters.
Thank you, Mr. Chairman. We'll keep these remarks brief. There are, as the commission is well aware, there are rules and then there are exceptions to rules. And the rule in this case is that a well has to be drilled no less than 330 feet from a lease or unit boundary in order to protect offsetting lands from unfair drainage. Exceptions are allowed in order to prevent waste or protect relative rights. Darrah Oil Company, the applicant here, seeks a well location exception for its Drummond number one well in order to drill the well approximately 100 feet from the protester's land. The proposed location of the well is a clear violation of protesters' relative rights. Further, as owner and operator of the oil and gas lease of protesters' lands immediately to the south, Darrah has the ability to conduct its geologic exploration on its lease, rendering the Drummond number well unnecessary and its drilling resulting in waste. So for that reason, Mr. Chairman, we would advocate denial of the application in this case.
All right, thank you, Mr. Rhodes. Now for staff, Mr. Marsh.
Thank you, Chair French. Staff has reviewed the application that was submitted by Darrah Oil Company for its proposed Drummond number one well. Staff believes that the application meets the requirements outlined in KAR 823-108. Based upon the information that has been provided to date, staff intends to recommend that the application be granted a full allowable, or the application be granted and a full allowable be assigned to the well. Thank you.
All right, thank you, Mr. Marsh. We will now go ahead and turn to examination of witnesses. So we will begin with operator, and Mr. Schlatter, you may call your first witness.
Thank you, Chair French. Darrah Oil calls Jared Lease to the stand.
All right. Good morning, Mr. Lees. If you're able to get yourself unmuted, I can see you trying.
There we
There
go.
you All right. Will you please raise your right hand for me? Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes.
All right. Thank you. Your witness, Mr. Schlatter.
Thank you. Mr. Lease, could you please state your name and job title for the record?
Yes, my name is Jared Lease. I'm a geologist for Darrah Oil Company.
And you're testifying on behalf of Darrah Oil Company today?
Yes.
And did you cause direct testimony consisting of 5 pages of questions and answers and exhibits identified as Figure 1 and Figure 2, and rebuttal testimony consisting of 6 pages of questions and answers to be pre-filed in this docket?
Yes.
And have you recently reviewed the testimony you pre-filed in this matter?
Yes.
And would that testimony be the same today as it was when you pre-filed the testimony?
Yes.
Do you have any corrections or other modifications to your testimony today?
No.
Thank you, Mr. Lees. I would move that the pre-filed direct and rebuttal testimony of Jared Lees be admitted to the record in this proceeding.
No objections.
All right. Hearing no objections, it will be admitted.
Thank you, Chair French. I would tender this witness for cross-examination.
All right. Thank you, Mr. Schlatter. Mr. Rhodes, the witness is yours for cross-examination.
Mr. Lees, my name's Thomas Rhodes. I'm attorney for the protesters in this proceeding. I'm going to ask you a few questions this morning about your pre-filed testimony specifically, and also to try to get some more detail on the conclusions you drew in the testimony that you filed. How did you select the proposed location of the Drummond 1 well being only 100 feet from the south line of what's been referred to as a merit lease? In this case, why not 330 feet?
I think 330 feet would put us too close to the old Moret well. I like this location due to the thickness of the chert and the structure of the Mississippi here.
Okay, well, you've testified that let me back up. Did the old Merit well produce from the Mississippian chert?
Yes.
And you've testified that the drainage area surrounding Mississippian chert wells in this area is fairly small, isn't that correct?
I believe it is fairly small, yes.
Okay. So where does the line of least interference occur between the Drummond 1 location and the Merit 6 location?
It's pretty hard to tell, but I think, you're probably, like within 100, 150 feet from the wells, probably where your drainage radius is coming from.
Okay, and where would that put it in connection with the Drummond well proposed location?
I don't know what you're trying to ask me with that.
Well, you said, if I understood you correctly, you said that the Merit 6 drained an area about 150 feet from the wellbore. Is that correct?
Theoretically, that's my theory.
Okay, and where is that in relation to the proposed location for the Drummond 1 well?
No, I don't know. It'd be 100, 200 feet from it.
So there is a possibility that you could have moved the well further north and still not encountered the drainage area for the Merit 6. Is that right?
That's still not going to put you far enough off the lease line, though.
If the Brown 3 and the Merit 6 wells produced from the Mississippian chert, which I believe was your testimony, are those wells depleted?
I mean, no, they're not. I mean, they're still the two Moret wells are still pretty good producers. They make, 2,700 barrels a year.
And how did you determine that that those wells, Murat 6 well in particular, only drains 150 feet from the well bore.
I believe when you do volumetric studies of the area, judged on the high porosity, low permeability of the formation, that formation will hold a lot of fluid, and you're only draining a small area with the volume of oil that has been produced from them.
Well, what specific measurements did you take besides the porosity and permeability to make that determination?
Basically, you figure your porosity and permeability, or your porosity actually over a given aerial area, and then you figure out how much fluid it'll hold, and then you can figure how much your oil percentage is, and then you can deduct how much fluid that area will hold, and based on your saltwater percentage, how much oil it will hold.
Okay, so this is based upon historical production from the Murat 6 well, is that correct?
Yes, and log analysis of the wells.
Okay. Where are the untapped Mississippian reserves that you're seeking to produce from the subject well here, the Drummond #1?
I think due to I think you have a small drainage radius, then that location between them two wells should have untapped oil there.
Between which two wells, excuse me?
The Murat 6 and the Brown 3.
Okay. And does the Drummond 1 well location sit between those two wells?
Yes.
Is it closer to one well than the other?
It's pretty close to each one of them. I mean, it's about even.
Okay.
It's closer to the Murat than the Brown.
All right. What other, you also were emphasizing the possibility of Mississippian line potential here. What
Yes.
is the what other Mississippian lime wells are in section 35? Which is section 35, by the way, refers to the Brown lease.
Yeah, there's 4 Mississippi lime wells that are now in that section.
Okay, and who drilled those wells?
Val Energy.
Okay, and is the where does the Drummond #1 well sit in relation to the Mississippian line wells in section 35?
It sits almost a half mile away from them.
According to the plat that accompanied your testimony, it looks like there are 2 other wells that might be as much as a mile away. Isn't that correct?
Yes. There's 2 that are within a half mile away though.
Okay. And what evidence do you have of Mississippian lime reservoir in at the Drummond 1 well location?
It's still kind of a wildcat drill there. You're within, pretty close to the producers that are good producers. Those wells are held confidential with all their data right now, so I can't access a log or anything for them. So basically just going off production data and a general, petroleum geology, we're going up dip from them wells. So I think we ought to do, similar results if we were to complete Mississippi lime there.
Your testimony mentions other Mississippian chert locations on the Brown lease. Why did you decide to drill a well 100 feet from the Brown lease instead of drilling a well on the Brown lease to develop those Mississippian chert locations?
I'm drilling my locations picked basically off structure and production. The Murat produces better than the Brown, so, and you're up dip from the Brown at this Drummond location.
Well, you think there's Mississippian chert potential on the Brown lease, isn't that correct?
It's possible, yes.
And what is your reason for not developing that potential as well as the location for the Drummond number 1 well?
Because I want to pick the best location possible, and I think it's the Drummond number 1.
Do you understand that by drilling the Drummond number 1 at that location, Darrah Oil Company will be draining reserves, potentially Mississippi and Chert reserves, from the Brown lease without compensating the Brown lease mineral owners?
Objection. That's a speculative question that is beyond the scope of his testimony, and there's no evidence in the record to that effect.
Well, there is evidence in the record that the Drummond number 1 well is located 100 feet away from the Brown lease. Isn't that correct?
Yeah, I'll let him give his opinion if he has one.
Okay, so I think that given the small drainage radius, there's probably, I mean, there's a pretty high likelihood that we won't encroach on their rights there. We might not drain off of the Brown property.
Well, you said that the drainage radius was approximately 150 feet from the wellbore, correct?
It's impossible to know an absolute definite drainage radius.
And you also contend or admit that the Drummond number 1 well is only 100 feet from the Brown lease. Isn't that right?
Yes.
Okay. You say in your testimony that, in your rebuttal testimony, that the testimony of J.L. Brown, the protester, who represents the protesters in this case, as to uncompensated drainage and waste is unsupported. How do you support your statement that the testimony of the protesters is unsupported?
Like I went through earlier with the, the volumetric calculations and our estimated drainage radius site. That's just back to what I said in the last question.
So you do not believe that there will be any uncompensated drainage or waste associated with the drilling of the Drummond number 1 well at its proposed location?
I don't think so, but it's impossible to know for certain.
Would you object, or would you may not be in a position to respond to this, but do you think it would be appropriate for Darrah Oil Company to, since it has the offsetting lease, to drill a well equidistant from the lease line as the Drummond number 1 well?
I think this is a land issue, honestly.
Okay. That's all those are all the questions I have for now. I'll tender the witness.
All right, thank you, Mr. Rhodes. Mr. Marsh, does staff have any questions for this witness?
A couple, Chair French.
All right, please proceed.
Thank you. Good morning, Mr. Lees.
Good morning.
In your testimony, you indicate that the well will be completed in the Mississippi Chert, correct?
Yes.
And I think in your testimony, you also mentioned the Mississippi line being a secondary target below the Mississippi Chert.
Yes.
Will Darrah target both zones or produce from both zones at the same time, or does it intend to test the Mississippi Chert first and then see what happens with the Mississippi line?
The plan is for the Chert first, so we will drill a well through the Mississippi line and assess it with logs.
Okay. And I think earlier you mentioned that you would anticipate the drainage radius in the Mississippi Chert being 100 to 150 feet. Is that correct?
Yes.
Would it be the same for the Mississippi line, or would it be a different radius?
It's hard to tell on the Mississippi line right now, like I said, due to the data being confidential, without being able to see logs and how big of interval that they're completing in those mist line wells. But typically in this area, you see mist line, they perforate at least a 30-foot interval and put like a 5,000 barrel frac on it. So you're probably looking at a small drainage radius with that too.
Okay. Thank you. That's all the questions I have.
All right. Looks like we are ready for commissioner questions. Commissioner Keither, do you have any questions?
I don't at this time. Thank you.
I think I've got just a clarification of what I think I heard on cross-examination. It sounds to me like we've established that there is a drainage radius of up to 150 feet. And I know you said it's hard to tell exactly, put an exact number on it, but I think you said 100 to 150 feet. And obviously, you're asking for a drilling location within 100 feet of the property line. And then when it was, I think you were asked by Mr. Rhodes, whether there would be depletion from under the Brown lease. And your answer was, I can't say it won't happen, or I can't, I don't think it's likely, but I can't say 100%. I just want to make sure that I understand that's kind of an accurate spot of where we are. You don't think it's likely, but but there is a possible drainage radius that would sit under the neighboring property.
Yeah, like I said, it's impossible to know for certain whether you're gonna, I mean, you can't look down there and tell where the oil come from, so it's kind of hard to tell,
Okay. And then I think I also understood your testimony that there would be no fruitful place for Darrah to set back the well location an additional 50 feet.
I mean, I like this location best out of anything I can come up with here, so that's why we.
Okay. Did you consider locations that would be set back an additional 50 feet, given the fact that your testimony indicates a potential drainage radius of 150 feet?
I guess I really haven't considered that.
Okay. All right. I don't think I have anything more. Mr. Schlatter, would you like to redirect?
Just a few, kind of more in the line of clarification questions as well. Mr. Lease, you testified a little bit about volumetrics and fluid. I'm going to do my best to ask you a question on those scientific topics. And if you don't understand what I'm asking, you just let me know. You mentioned the thickness of the chert, and in your pre-filed testimony, you comment on porosity and permeability and how this particular formation has good porosity but poor permeability. When a well is drilled and it drains fluid, does it drain fluid equally the farther out you get, or is there a disparate impact the further you get out, or vice versa?
Well, it's going to drain the area closest to the wellbore first, and that's mostly what it's going to drain in this case. When you have a high porosity, low permeable reservoir and you frack it, you're going to put, like however much fluid worth of frack you put in there, that high porosity is going to take most of that fluid close to the wellbore, and it's going to create the permeability there. Now, if you were dealing with a low porosity, high permeable reservoir, then you would tend to have a larger drainage radius, and your frack would go further than with the situation we're talking about here.
So is it fair to say that whatever volume this particular wellbore may drain, that as you get further away, it will exponentially decrease as you move away from the wellbore?
Yes, I would agree with that.
Okay. What does it cost, I mean, AFE wise, to drill and complete a well out here?
I think Mike would know more, a certain number on that.
Can you ballpark it for us?
I would say 500,000, 550.
$550,000?
Yes.
And that's a substantial sum of money. And so when you select drilling locations, do you select them based on the highest probability of success?
Yes.
And if you were to move closer to an existing wellbore, would that decrease the possibility of success?
I think so.
And so you would spend money that you may not recover through production?
Yes.
Okay. That's all I had on those topics. I'd submit him for recross.
Yeah, I think based on where we went with some of the questioning, I will allow an opportunity for recross. So, Mr. Rhodes, if you have anything additional.
Just briefly, the reference was made to the fluid production. There's also some reference in the witness's testimony concerning the concerning fracturing as well. Is that right?
Yes.
Okay, and that's going to entail the injection of a substantial volume of water, right?
Yeah.
And that would be in addition to the water that's already in place, to the formation water that's already in place, correct?
Yes. But
So,
oh, go ahead.
well, no, go ahead.
Well, the porosity that you're filling with that frac fluid, there's so much of it there that volume, even though large, isn't going to go very far.
Okay. Have you had a chance to try to quantify that at all?
Well, like I said, with the volumetrics, you know how much that formation will hold based on the porosity. And if you put that amount of frac fluid in there, you can, get an idea that it's not going to go you're not going to send it a long distance away from the well.
What is what's your plan for the disposition of the water that's going to be produced from the proposed well?
I don't know on that.
Do you know of any disposal facilities in the area that might be used for that?
I don't know. I haven't been asked to look into water disposal for it, so I haven't looked at that.
Very good. That's all the questions I have.
All right. I think at this time we will move on unless there is any need for additional questioning or redirect.
I have no more questions.
Okay. All right.
No questions.
All right. Very well. Mr. Lease, we do thank you for your testimony. You may virtually step down.
You're welcome.
And with that, Mr. Schlatter, you may call your second witness.
Thank you, Chair French. Darrah Oil calls Mike Atterbury.
Good morning.
Good morning, Mr. Atterbury. Would you please raise your right hand for me? Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you, Mr. Schlatter. You may proceed.
Thank you. Mr. Atterbury, would you please state your name for the record?
Michael Atterbury.
And for whom are you testifying in this proceeding, and in what capacity?
Darrah Oil as land manager.
And did you cause to have direct testimony consisting of 7 pages of question and answers, and rebuttal testimony consisting of 6 pages of questions and answers to be pre-filed on this docket?
I did.
And have you recently reviewed this testimony?
I have.
And are the answers you provided the same today as they were when you pre-filed the testimony?
They are.
And I noticed one thing in your testimony, specifically your rebuttal testimony, references an Exhibit A, which was not attached, but is an oil and gas lease that we're calling the Brown lease, which is the same as the oil and gas lease attached to the rebuttal testimony, Mr. Brown.
Correct.
Okay. With that, I would move to that the pre-filed direct and rebuttal testimony of Mike Atterbury be admitted to the record in this proceeding.
No objection.
Hearing no objection, the referenced testimony and exhibits will be admitted.
Thank you. I would submit this witness for cross-examination.
All right. Thank you. Mr. Rhodes, the witness is yours if you have cross-examination.
Thank you. Mr. Atterbury, I'm Thomas Rhodes. I'm an attorney for the protesters in this proceeding. I'm going to ask you a few questions. Your testimony, and I can't recall whether it's the direct or the rebuttal, but I believe in the direct testimony, you discuss attempts to obtain unitization authority for the Brown lease from the protesters. Tell me, why do you think that the protesters are under any obligation to agree to unitization?
I don't think they're under any obligation. I don't think that's necessarily the way I would put that.
So then why did you, what was your purpose in seeking that unitization authority from for the Brown lease from the protesters?
To be able to drill the well at which my geologists have requested is the best location to drill.
But wouldn't you
Oh.
agree that, go ahead. I'm sorry.
To drill it at that location as a unit location for both parties.
But if there was a unit formed, wouldn't you agree that unitization would deplete the protesters' mineral reserves at a reduced royalty? Basically for Darrah Oil Company's convenience, isn't that correct?
I'm not an engineer or a geologist to tell you whether that would reduce his drainage.
I'm not talking about drainage, I'm talking about the royalty.
Anytime there's a unit formed, as per the statute, it's based on surface acreage that's put into the unit, and that's how it is calculated. The percentage is calculated.
Okay, so the unit that you proposed would have reduced the protesters' royalty on hydrocarbon reserves that are produced by the proposed well, isn't that right?
It would have reduced it to the extent of the acreage included in the unit.
If a well was drilled on the Brown lease, what percentage of the royalty would the protesters receive?
As a unit or as a 330?
Without unitization.
1/8.
Okay. And with unitization, the protesters' royalty on production from the Drummond #1 well would be less, would it not?
It would be less than 1/8, correct. It would be his share of the 1/8.
Based upon the acreage attribution, correct?
Correct.
You're familiar with the Brown lease that was executed in 1975, aren't you?
I am.
Okay. And were you aware that the unitization clause in that lease had been deleted when Darrah Oil Company acquired it?
I was not aware when we acquired it that it had been deleted, but in subsequent, as we've reviewed the lease for further development, yes, I've then seen that it had been strucken.
So you did not know the terms of the lease when Darrah Oil Company acquired it from Range Oil Company or from Richard D. Smith?
Not when you acquire numerous leases, not every one of them can I tell you that we knew individually. Yes, we've reviewed them all prior to acquiring them, but to say that I knew exactly on that one, no. We have a lot of leases. I can't remember the terms of every one of them off the top of my head, sir.
Despite the absence of utilization authority in the Brown lease, the protesters nevertheless offered to allow the formation of a 40-acre unit in order to share in the royalty on production from the Drummond well. Isn't that correct?
That is not correct. They offered to allow a 40-acre unit if we gave up our lease rights that we currently hold and added additional clauses that would prevent us from further developing the lease in the future.
But nevertheless, there was an offer to permit Darrah Oil Company to form a 40-acre unit, correct?
Not with our current lease, no, sir. They wanted us to eliminate the lease that we currently have, execute a new lease, and give up our rights to be able to form a 40-acre unit. Okay.
And is that the reason why the protesters' offer was not accepted by Darrah Oil Company?
His offer was unreasonable to ask me to give up land rights that we've held for this long and add additional terms that would prevent further development at the same time that they have already executed a top lease on the acreage, sir.
Okay. Did you, Darrah Oil Company has some kind of a business arrangement with Zenith Drilling Company for drilling the Drummond number 1 well. Is that correct?
That is correct.
Okay. And when protesters offered to allow the formation of a unit in order to facilitate drilling in the Drummond number 1 well, did Darrah Oil Company review that offer with Zenith Drilling?
Zenith Drilling has asked us to handle the situation at hand.
So Zenith Drilling was never aware of the offer that was made by the protesters. Is that correct?
We've sat down and I've talked to them several times about the situation. So I don't have that to tell you that I've written them a letter, but yes, we have sat down and talked to Zenith Drilling several times about the situation and discussed that they were unwilling to amend and this was the route we were going. So yes, they are aware.
Is it your understanding that the protesters are asking for the north half of the northeast quarter of Section 35 to be released from the Brown lease without any consideration to Darrah Oil Company?
Say that again, please.
Is it your understanding that the protesters, in offering to allow a 40-acre unit, are suggesting that the north half of the northeast quarter of Section 35 be released from the Brown lease without any consideration to Darrah Oil Company? Is that right?
They are asking for it to be released in exchange for offering the 40-acre unit, but there's other stipulations that we're asked to as well, which we're unwilling to.
I'm sorry, say that again.
They are asking for not just that. There's multiple stipulations they're putting on it.
Okay, can you specifically explain why those other additional considerations were not acceptable to Darrah Oil Company?
We have a lease that we have land rights on, and when we asked to amend the lease to increase a unit or to be able to amend the lease to get a unit, to drill a well to directly compensate the protester, we were asked, or we were told that their offer would be to release the lease to the North 80. They would grant the 40-acre unit. It was a 6-month lease with a pew clause that would get rid of our land rights, which have been held under this lease for some time. And if we did not, within the 6 months, all the land outside the units would be dropped and we'd be unable to do it. On top of that, it's a no drill lease that was requested. So at no point could we drill on that North 80, even if we did have a lease on it. That is unreasonable in our eyes for land rights that we currently hold.
So what's preventing Darrah Oil Company from drilling a well on the Brown lease currently with or without a unit?
Again, I'm not a geologist. My geologist directs our locations. They pick the best one that they think is going to be the most likely for success. When we're investing that much money, that's where we have to go.
But if drilling on the Brown lease was necessary to preserve Darrah Oil Company's rights to the north 80 acres of Section 30 or the northeast quarter of Section 35, wouldn't you be in favor of drilling such a well?
It was a no drill lease.
Hold on, Mike. I'm going to object to that question. It's laden with legal conclusions. There's no argument that the lease, or there's no, that the lease is valid as it sits today. There's no argument or pending litigation that is necessary, that there's a requirement to drill a well to hold that acreage. The lease.
I'm sorry. Mr. Oh, go ahead.
Yeah, I fumbled through that quite a bit.
Well, I think I heard the objection, but unfortunately, I don't think I was listening closely enough to the original question. So I was going to ask Mr. Rhodes just to restate his question, and then maybe we can start all over again. To the extent Mr. Rhodes wants to go there.
Well, my question is why not drill a well on the Brown lease if as both witnesses for the applicant have acknowledged there is Mississippi and church potential on the Brown lease, and drilling on the Brown lease would help preserve the rights to the north half of the northeast quarter of section 35 that the witness here is indicating would be lost with the offer to unitize that the protesters have made.
And that's the latter half of that question is what I'm objecting to. It's a legal pretext that there is any such legal obligation to drill on there to preserve those rights. That's just not true. If we could strike that, I think the question could be answered.
Yeah, I think I'll sustain the objection to that degree. I mean, I guess from a geologic or business perspective, you could answer the first question of why not drill on the Brown lease.
You ready for me?
Yeah, go ahead.
Sure. Again, take direction from the geologist on the most likelihood of success. When you're spending that much money, you obviously go after what you want to go after for your number one location first. What they've recommended is to drill the Drummond number one. And so my goal was to move forward with both landowners, try to get everybody together and get the lease and get the well drilled at the location.
Mr. Atterbury, do you consider this application to be fair and equitable to the protesters in this case?
I do believe it to be fair and equitable. Yes, sir.
Okay. So how is a well location exception for the Drummond number one well that drains the protesters' Brown lease reserves without compensation to the protesters fair and equitable to the protesters?
Objection again. We've put evidence that's not in the record. There's no evidence that it's going to drain underneath his lease. That's again a pretext. Again, I think the question's been asked and answered too, as the fair and equity portion of it.
Well, we have testimony that there is a possibility of some drainage, and we have testimony of the likelihood. You cleaned that up and got some clarification on redirect. So I think Mr. Atterbury could offer his opinion on why it's fair and equitable. Go ahead, Mr. Atterbury.
I'm not an engineer or geologist to talk about drainage. That's not what I do.
So you have no opinion on whether this is fair to the protesters or not. Is that right?
What I can tell you is what you have proposed, or the protester has proposed, is exactly the opposite of fair and equitable, in my opinion. We've looked at the unit that you guys proposed for us to drill. It would obviously be a well not on his property, and he would be entitled, per your offer, at north of 2/3 of the unit for a well not located on his property. So if you're asking me about fair and equitable, the proposal that you guys put forward is by far not fair and equitable to his neighbor.
But you just got through explaining that's the way unitization works. Isn't that correct? It's on an acreage attribution basis.
We are only allowed, we have a 10-acre unit to build. And the description that you guys have put in allows for it to be more acreage on your side on a well not on your acreage, or on Mr. Brown's acreage, that would allow for more than 2/3 of the royalty on a well not on his property.
So how does that violate the normal procedure for unitization?
It is not in standard form around the wellbore is what you have proposed.
Okay. Why couldn't all of this be avoided by just simply drilling a well on the Brown lease?
Again, we are drilling based on geologist recommendations on the most likelihood of success to prevent waste.
Okay. You mentioned that there was a top lease on the Brown lease. Is that right?
There is correct.
And how's that top lease? Where's that shown in the record?
At the courthouse, sir?
Yeah, I know. We're in the courthouse.
In the index books?
What is the document? What is the document that creates the top lease?
A top lease agreement.
Okay, and who is who's the lessor and the lessee in that top lease agreement?
Val Energy and J.O. Brown.
Okay, and you say it's a matter of record in the courthouse,
Correct.
but you don't know exactly where that record resides in the courthouse. Is that
I
right?
don't have the exact book and page, but it is of record in the index books.
Okay, and do you have access to exhibits that the protesters have filed in connection with this hearing this morning?
Some. What specifically are you asking me about?
I'm asking you about protesters exhibits numbers 1 and 2.
I do not have them with me at the time.
John, can you, I know we have them. John, can you share them on Zoom? Do you want to start with with one or the other of those, Mr. Rhodes?
Well, I'll start with exhibit 1.
Okay. And just start out by, once John gets it up, if you could just start out by identifying it and describing what it is we're looking at.
Give me one moment.
Thanks, John.
Actually, something's not working quite right, so give me a little bit longer than one moment.
I might be able to help out there. John, if you want me to, and Tom, if you don't mind me driving.
No, just as long as you don't ask any questions yet.
I think I've got it now. Is that showing all right for everyone?
Yes.
Sorry about that.
Mr. Atterbury, can you see that?
I can.
And is that the top lease you're referring to?
Can you scroll down? Is this the 2020?
2022.
That's the first one. Yes.
And there's more than one?
Correct.
Okay, and that's the second exhibit, is that right? I can't read that.
This is exhibit number 1.
Exhibit number 1, okay. Is this, tell me again, is this Mr. Atterbury, is this the top lease that you're referring to of the Brown lease?
I believe so.
Okay. If we could, and I hate to complicate matters, but if we could turn to exhibit number 2, protester exhibit number 2, we'd like to review that. Mr. Atterbury, are you familiar with this document?
I am.
And what is your understanding of what it purports to show?
It releases the first top lease, but not the second one.
What does the second top lease consist of?
A similar document creating a top lease in 2023 that was never released.
Okay, and do you have a copy of that? Is that entered into the record anywhere?
At the courthouse, sir.
And who is the lessor and the lessee on that second top lease?
Val and Mr. Brown.
But you don't have a citation, you don't have a book and page number for that second top lease, is that right?
No, sir.
And you don't have a copy of it to present to the hearing this morning, correct?
I don't hear, no, not with me.
If the purpose of drilling the Drummond number 1 well is, I think as you've described it, is infill drilling, is that correct?
I didn't describe it as that, no, sir. I described it as the location that my geologist picked for the most likelihood of success.
Okay. Did, how will drilling on the protesters' land on the Brown lease, how will that be prejudicial to Darrah Oil Company?
I'm not sure what you're asking me.
Well, you said you've rejected the unitization offer made by the protesters. You've indicated that drilling on the Brown lease would not be the best location for a Mississippi insured well. Is that right?
Based on my geologist, and I think you have the testimony already, he says that the Drummond #1 is the location that is most likely to be successful.
Okay, so are you also saying that drilling on the protesters' land on the Brown lease would be prejudicial to Darrah in some respect?
All I'm saying is that the Drummond #1 is the most likely of successful well to be drilled.
Again, under the proposal that's made with this application, no part of the royalty on production from the Drummond #1 well will be paid to the protesters. Is that correct? Is that right?
Correct. That is correct at this time.
Okay. So again, my question is, assuming that there is the possibility of drainage of the minerals associated with the Brown lease, would it not be better for Darrah to drill on the Brown lease than it would be to I understand your geological influence, the influence of the geologists and so forth in choosing a location. But as far as the equities of this situation are concerned, would it not be better to drill on the Brown lease than it would be to drill at the Drummond #1 proposed location?
I'm not sure what you're asking me. It's the location that we drill that we have requested. The Drummond #1 is the most likelihood of success.
Without regard to the impact on the protesters' mineral rights, is that correct?
Well, I mean, I think that's why we're here, sir, because we tried to work with him to amend the lease so that he would be part of the unit.
I think my curiosity is satisfied for the time being. I'll tend to the witness.
All right, thank you. Does commission staff have any questions of this witness?
I don't believe so, Chair French.
All right, then we would turn to commissioner questions. Commissioner Keither, any questions?
No questions. Mm-mm.
And I don't believe I have any questions of you, Mr. Atterbury, but we will allow Mr. Schlatter, if you have any redirect.
I think just a couple things real quick here. And then we'll move, and that'll be it. There was, Mr. Atterbury, there was questions about fairness and equity.
Mhm.
And references to Mr. Brown's royalty being reduced in the event of a unit. Would it be fair and equitable to drill a well on a unit location that includes Mr. Drummond's land and not allocate some share of the royalty to him?
No.
There was also a question about how Darrah Oil would be prejudiced if they were forced to drill a well on Mr. Brown's land. What's your idea of what it would cost to drill a well out there?
They are right around 500,000 to drill and complete a well.
And when you're spending $500,000, do you want to choose your best location or your worst location?
Obviously your best. That's a big number.
So if the reserves were not as good on the Brown lease, which I believe the production records reflect, what would the impact be to Darrah Oil to spend $500,000 in drilling a well on his lease?
It's unknown how the damage could be. Obviously, you want your best location when you're spending that much money. If it's not as good.
Oh, go ahead.
I'm sorry.
Please finish what you're saying.
When you're spending that much money or you're going out, you want to drill your best location with the most chance of preventing waste and recovering the most reserves.
Because the reserves are sold for money, correct?
Correct.
Very good. There were some questions about the top lease, the February top lease, and I do have a copy of that. I can share that with you so you can authenticate it for the record here today. This is, split my screen here because this is a mess.
There we go. Yep, I can see it.
You can see it okay?
That's the 23 lease. Yep, correct.
Okay. Oops. So, geez, figure out how to scroll down here. This is a lease granted by, damn it. Now I'm fumbling through Zoom. All right. Can you see the lease that I'm looking at here?
I see an affidavit of production currently.
Okay, that's the wrong thing. Here it is.
Yes,
Okay.
I see that.
Okay, perfect. This is the 2023 top lease you were referring to?
Correct.
It's recorded at book 115, page 746 in the Cowley County Register of Deeds. Dated February 2nd, 2023 from RJ Resources to Val Energy, Inc. RJ Resources is signed by James O. Brown as managing member. This
Correct.
particular lease covers section 3, which is not at issue, but references an attached addendum at bottom. Do you see that?
I do.
And these pages are obviously upside down. Here is the addendum to the oil and gas lease attached. This addendum incorporates section 35, Township 3, 33 South, Range 5 East. Do you see that?
I do.
And that is the acreage at issue in this case, at least as far as the Brown lease is concerned.
Correct.
And this is the top lease you're referring to that was not released by that disclaimer Mr. Rhodes showed you earlier. I believe
That is correct.
This was exhibit 2. Is that correct?
That is correct.
Okay. That's all I have there. I don't believe I need to offer this into the record because it is a public record and the commission can take judicial notice of it.
Would you like to request us to take official notice?
I can, and I can produce this separately after the hearing if that's all right.
Yeah, we will go ahead and take official notice of it, and if you would just file it into the record, so that any references to it in this transcript, people can then go to the record if they want to see it.
Very good. I will mark it as applicants B.
Okay. All right. Let me just double check. We didn't cover much on additional questioning there. Mr. Rhodes, do you have any need for additional recross?
Just a procedural comment, Mr. Chair. I think with the introduction of this new exhibit, we would like a chance to submit rebuttal exhibits if possible. Because I believe they're out there. We just have to locate them.
Are they the exhibits that you previously filed, or do you have additional exhibits?
No, these would be additional exhibits because the exhibits we previously filed were directly related to the witness's testimony, but the witness now has come up with some additional evidence that we were not aware of at the time the pre-filed testimony was filed. And we haven't really learned much about from the witness's testimony.
My only comment to that would be that Mr. Brown signed this particular document, so I don't believe it's fair to say he wasn't aware of it.
Well, RJ Resources is not one of the protesters or one of the owners of the mineral rights in and to the northeast quarter of Section 35.
Are you suggesting that James O. Brown of RJ Resources is a different person than the man sitting next to you?
I'm not suggesting anything. I just want, that's what I'm trying to figure out is
So-
exactly where this lands.
So we've already taken official notice of these documents. Mr. Rhodes, if you would like us to consider additional exhibits, why don't you it would be fine with me if you file a post-trial motion with anything attached, and we will consider it. It would
Very
give
good.
the other parties an opportunity to comment, and but then we would have an opportunity to receive that into the record.
Very good. Thank you, sir.
All right. With that, I think there are no more questions for this witness. Mr. Atterbury, we thank you for your testimony. You may
Thank you.
also virtually step down.
Thank you, Chair.
All right, let me check my agenda here. We have made it all the way through operators, witnesses. I think we will keep going. Why don't we go ahead and move to protester, and you may call your one witness.
Thanks, sir. I'll call J.O. Brown.
Mr. Brown, can you please raise your right hand for me? Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. Mr. Rhodes, you may continue.
Thanks, sir. Mr. Brown, would you state your name and address for the record, please?
Okay, for the record, it will be James O. Brown, 11923 252nd Road, Winfield, Kansas. I do go by and recognize J.O. Brown.
Very good. Thank you. Are you familiar with the application for well location exception that was filed by Darrah Oil Company in this docket?
I believe I was notified by mail.
Okay, so you've had a chance to review the application, correct?
Yes.
And did you file a protest on behalf of all the affected surface and mineral owners?
To my ability, I did.
And you also filed, did you not, pre-filed testimony, both direct and rebuttal that appears in the record? Is that correct?
That is correct.
Okay. And are there any changes to that testimony you would like to make, or do you approve the testimony as submitted?
I have read it over and compared it to what I had before. It looks like it's identical, so I wouldn't have any reason to rebut any of it. It would be my approval.
Very good. And do you, at this point, I'd like to request that the pre-filed testimony and direct and rebuttal testimony of the witness be admitted into the record.
Any objection?
No objection from applicant.
Hearing no objections, the reference testimonies and exhibits will be admitted into the record.
Mr. Brown, you're here on behalf of the owners of the surface and mineral rights to the northeast quarter of Section 35, Township 33 South, Range 5 East. Is that correct?
That would be correct.
And that acreage is subject to a producing oil and gas lease currently owned and operated by Darrah Oil Company.
That is correct.
Okay. And is there a production?
Just a sec. May I ask what we're doing here? Are we doing additional direct?
I thought
Yeah.
you might speak up here. So, Mr. Rhodes, we do have a regulation that requires all the testimony, the direct testimony, to be pre-filed. Now, sometimes we will relax that if there is an equitable need to add some additional direct testimony, but normally we let the written testimony speak for itself, then we do cross-examination, then we do redirect. Is there some equitable reason why we would need to add to the direct testimony in this case?
No, Mr. Chair, I was just simply trying to confirm what has already been stated by the witness in the pre-filed direct and rebuttal testimony.
All right, if it's already in the written testimony, let's just consider it part of the record as if he had made that testimony here today. And I think if it's all right with you, I would ask you to tender the witness for cross.
Do so, sir.
right.
Thank you.
Thank you. Thank you very much. Mr. Schlatter, you may proceed.
Thank you, Chair French. Good morning, Mr. Brown. My name is John Schlatter. I'm the attorney for Darrah Oil in this matter. I've got a few questions about the testimony that you pre-filed in this docket. And so I'm going to be asking you those questions, alrighty? In your direct testimony, specifically at page 12, page 3, lines 12 through 13, you opined that drilling the Drummond well at the proposed location will violate correlative rights and result in waste. Is that correct?
Yes.
Is your opinion based on any educational background in the field of petroleum geology or engineering?
I've had a course in geology, and I know the Kansas law that says 330 feet is the perimeter that the oil company can drill on.
So you learned about the 330-foot setback in the course you took?
No, I learned that from my dad back in 1960.
Okay. Have you received any formal training in the fields of petroleum geology or engineering?
Only the experience I've gotten out in my pasture.
And have you ever worked in the field of petroleum geology or engineering?
No.
Okay. I'd like to turn to the letters that are attached to your rebuttal testimony, specifically in your rebuttal testimony at page 1, lines 10 through 19. You adopted 2 letters that your attorney wrote for you as your rebuttal testimony, and I believe those have now been admitted to the record. Those are marked as Protesters Exhibit 4. Mr. Rhodes marked those as Protesters Exhibit 4 for us. I'm going to publish that to you if that's all right, just for foundation purposes.
Okay.
Okay, the first letter, and you can see here it's marked as Protesters Exhibit 4. The first letter is dated August 14, 2025. It's from Mr. Rhodes to Kelsey Marsh as litigation counsel. It contains 3 pages of narrative and a copy of an oil and gas lease attached there too, which is 4 pages long. The second letter is a letter dated May 19th, 2025. From Mr. Rhodes to myself on as Morris Lang as attorney for Darrah Oil, and that letter is 2 pages. Do you see that?
Oh, yes, I've got it now.
Okay, and I just want to confirm that these are the 2 letters attached to your pre-filed rebuttal testimony, so that we can make this exhibit part of the record.
Yes, it It is.
Very good. With that foundation, I would offer protesters Exhibit 4 into the record.
No objection.
Just for my clarification, are these exhibits the items that are already attached to Mr. Brown's testimony and thus already part of the record?
It is.
That's correct. We kind of talked about this beforehand because they weren't marked. It might be easier to reference them during the hearing as an additional exhibit. But either way,
Okay.
this is purely a matter of making a record and not anything beyond that.
All right, so they are not marked. Oh, okay, I see what you're saying. Yeah, we can go ahead and admit them as additional exhibits that are marked. So they will be admitted. And can you please just identify again what their markings are?
This has been marked as protesters Exhibit 4, and as the witness testified, this exhibit is the same as the materials attached to his pre-filed rebuttal testimony.
All right, very good. Thank you.
Mr. Brown, I'm going to refer to the first letter here, which is actually the latter dated letter of the two. The letter
Right.
dated October 14th. At bottom, you state that it is the policy to prohibit the formation of units from leases. That was a family policy, is that correct?
That is correct.
And so the family policy was, we don't allow unitization in our oil and gas leases.
No, the family policy was we don't share with others. So therefore, there was no unitization allowed.
And that's a policy that you've continued today.
Yes,
And the justification for this policy, as you just stated, is that you don't share with others.
that is correct.
And in the letter, you reference a justification, and I'm at the top of page 2 here, that says, to prevent drilling and associated damage on their land under the terms of a unit that proportionally reduces their share of royalty on production from their land. Correct?
I believe that's what it says.
And you believe that to be fair?
I believe so.
Okay, I'm going to come down now to the second letter, which is the letter dated March 19, 2025. There's been some testimony, I think with Mr. Atterbury particularly, about your proposal in which you would allow for unitization of a portion of your lands. And I want to highlight this part in the middle here and kind of just walk through this with you. Okay, again, this is a letter from your attorney to me that you've adopted in your testimony. It says, protesters will agree to grant Darrah Oil a new oil and gas lease on the north half of the northeast quarter. Is the implication there that Darrah Oil's existing lease covering that acreage would then have to be released in order for a new oil and gas lease to take effect?
That was my intent, that if they wanted that 40-acre unit for unitization, they were going to have to give me something in return. After all, I don't want unitization on our property.
Because you don't want to share with the neighbor?
That's right.
Okay. So this is the new offer then here. We give a new lease, that's what you're asking for, and these are the terms or the provisions. I believe Mr. Atterbury referred to them as stipulations that would be included in this new lease. The first is they would have a 6-month term. Do you understand what that means?
Yes,
Could you just elaborate quickly?
it means that with the new lease, they have it's a 6-month term to do with the drilling of the well. And if they don't have that, then after 6 months, that lease is over because they didn't fulfill their 6-month obligation.
So the lease would expire as to the 80 acres if a well wasn't drilled and drill and
That-
completed in 6 months.
That is correct.
Okay, the second stipulation is here. It says you will permit the formation of one 40-acre unit for oil. Is that correct?
Yes, that is correct. That's what we came up with.
So if Darrah Oil could form a 40-acre unit, a portion of that acreage would be on your neighbor's land and a portion of that acreage would be on your land, right?
That would be correct.
And then it says that the production from the unit will only hold acreage from the new lease in that unit. Does that mean that after this unit is formed and 6 months expires, that all of the acreage on your new lease would then lapse and exterminate?
That's not what we meant, was it? No, that wasn't what we meant.
So providing that production from the unit will only hold acreage from the new lease included in the unit means that the lease remains in effect as to the acreage in the unit, but if the acreage is not in the unit, it would expire after 60 months? After 6
Yes.
months?
Yeah, that you have that concept right.
And then the last provision is that this is a non-drilling lease, so that production from the unit will have to be from a well located on acreage contributed to the unit from the Moret lease.
That would be correct.
So under this proposal, Darrah Oil could have kept some portion of 40 acres from your new lease, but has no ability to keep the balance of that acreage, correct?
That would be correct.
Okay, I'm going to scroll down a little bit farther to the second page of this, what we're calling the second letter, the May 19 letter. And this is one final demand or request, and I've highlighted it here. It says, we expect that the unit to be formed will have its north boundary located 430 feet north of the south line of the Moret lease, and the south boundary located 890 feet south of the north line of protesters' parties. Is that correct?
I haven't stepped that off. I don't really know for a fact, but I'm assuming that those figures that was given to me are correct, so I will agree to it.
Okay, and it says a different configuration may be acceptable so long as it does not reduce protesters' royalty on unit production.
That would be correct.
So you would agree to a differently shaped unit as long as you get the same royalty as contemplated by this particular provision.
Basically, that would be correct or right.
And then, of course, the letter also says the unit will be 1,320 feet wide. So we're talking about a square, basically.
Yes.
Okay. I'm going to show you what I've marked as, if I can get all this Zoom stuff out of the way. Applicant's Exhibit 5. Can you see that?
Yeah.
I'm sorry, Applicant's Exhibit A. Can you see that all right?
Yes.
Okay. And this is intended to demonstrate some of the provisions that you included in this letter. I've identified, this is a printout from KGS. So this is section 2633-5 East. This is the Moret lease here, this south half of the southeast quarter of section 26. Can you see that?
That is correct.
And then I'm going to scroll down to the bottom here. And you can see that this is section 35, Township 33, Range 5 East. This would be the northeast section. This is the Brown lease or your land, correct?
That would be right.
Okay. And then the Moret lease, that ground is actually owned by Mr. Drummond. We've referred to Mr. Drummond in a while. I assume the Morets or somebody after them sold that ground to Mr. Drummond at some point in time, correct?
I'd like to make a correction on that.
Yes, sir.
My understanding is that Mr. Drummond is in the process of selling that property. So I don't know who owns it.
Okay. But Mr. Drummond or someone he may be selling it to is the owner of that property.
That would be a correct statement, yes.
Okay. I've highlighted here the proposed location of the number one well. That would be 100 foot north of the boundary between you and the Drummond property and 658 feet east of the east line of both of those properties. Do you see that?
Yeah,
And so as you proposed or insisted in that second letter, the unit would be configured in this fashion with 430 feet being north of the Moret South line and 890 feet being south of the Brown lease line on your property.
that would be correct.
So do you understand under this configuration that you would receive approximately 67.5% of the royalty from this well drilled on Mr. Drummond's land? And Mr. Drummond would receive approximately 32.5% of the royalty drilled on his own land.
I understand that if there wasn't any unionization and they drilled on me, I'd have 100% of my 1/8. And here in your square, I don't.
Correct. And that's not precisely what I asked. I understand under the unit configuration that you proposed, with 430 feet being contributed from the Moret lease and 890 feet being contributed from your lease, that your share of the royalty would be in excess of 2/3, and Mr. Drummond, who would bear the burden of the well on his property, would get 1/3 of that royalty. Is that correct?
That would be correct.
And do you think that that's fair?
Considering the problems, yes.
So you would have, you think that your family policy is fair, that if you have a well on you, you shouldn't have to share. Why shouldn't Mr. Drummond have the same policy?
I don't know what his policy is. I don't know the man.
Are you familiar with the phrase, what's good for the goose is good for the gander?
I understand that's what's good for the goose is the way it's going to be
Okay,
when it comes to our property.
sure. I believe that's all the questions I have. I'm going to stop sharing. Oh, I would like to move to admit this Exhibit A into the record.
No objection. I think that,
I screwed it up.
the, dimensions are, assuming the dimensions are correct, we have no objection.
All right, very well. It will be admitted into the record, and I have a feeling we may have you pull this back up at some point. I know it's helped me visualize the proposals that were in writing. So, all right, let's see where we are. Mr. Marsh, do you have any questions of this witness?
I do not, Chair French.
All right. Let's move to commissioner questions. Commissioner Keither, do you have any questions?
I don't, thank you.
All right. I think I may have a couple. First of all, we don't have to turn back to the testimony. Yeah, good morning, Mr. Brown. Sorry, I should have started with that. Thank you for being here today. We don't
I'm
have to
always
turn back.
overlooked. I'm always overlooked, so it doesn't matter.
Thank you. Well, Mr. Schlatter asked you about your testimony, where you stated the opinion that if the application were to proceed or be approved, that you believed it would be a violation of your correlative rights, but it would also be constitute waste. Given all the testimony we've heard today, I think I understand the concern that potentially there could be some violation of correlative rights, that there is some potential for drainage underneath your land. What I I think I don't understand is the contention that there would be waste. If you could elaborate on that for me.
Okay, can you restate that if you can?
Why, in your opinion, would approval of the application cause waste? Why would it cause less production of Kansas's oil and gas resources than what would occur if it is not approved?
If Darrah has signed some agreement, which I'm not aware of, to Zenith, why don't they move 330 feet north of the property line and we wouldn't be here? Or Darrah move south of the property line 330 feet and we'd also have the same solution. There's no need for unitization.
All right, as I understood it, in your own words, the unitization provisions were deleted from your lease, sort of based on family policy, before you, but you've continued it, and it was sort of this, as you stated it, we don't share with others. We don't share with the neighbors.
Sir,
Yeah, go ahead.
if you'll note in those letters, there's two leases, one from Donald Brown to Smith, Dick Smith. The other lease is Ray Murrett, a neighbor of ours, that he signed with Zenith. There's no unitization in there. My dad and Ray both felt the same way. What's on your side of the fence is yours, and what's on my side of the fence is his. So there was no squabble about any of it. We weren't trying to gouge anybody.
So what I'm trying to square, though, is it looks like you have made a counter proposal here, which would be a unitization, which would contemplate some sharing with the Drummond. Now we can talk about whether that sharing is equitable or not. I understand that's the basis of the dispute, but what you've proposed would be a unitization, right?
Yes, wouldn't that be pathetic?
All right, I just want to make sure I had that clear. I don't think we have to pull applicant's Exhibit A up again. I can visualize it in my mind. The square that sits looks like 2/3 on your land.
They printed out
Um,
like that.
is there what was the basis for that proposal? Was there any geologic or production basis for that unitization configuration? Or was it simply just a negotiation?
It's kind of water underneath the bridge now. I don't really recall why we came up with that configuration. It's just that that's the way the measurements fell.
Sorry, you say that's the way the measurements fell.
On the map. I mean, when we were talking, we weren't out there in the pasture, or I wasn't looking at any map. We were just stating facts, and what they finally came up with was the square that you see on your map.
So that square doesn't fall
It doesn't
over
doesn't
something
hold water.
specific on a geologic map or anything.
No.
Okay.
It's like two ranchers get together and decide to build a fence, and they want the square here, and there's access on one side and then on the other, so they decide to share it, the pen. We don't care what the dimensions are. That's what they fell on when we got out there. So that's how that square came to be. It wasn't exact science by any means.
All right. I don't believe I have any more questions for you, but I will then turn it to Mr. Rhodes if you have any redirect.
Just briefly, Mr. Chair. You made this offer, Mr. Brown, to allow unitization in order to facilitate drilling of the Drummond number 1 well by Darrah. Isn't that correct?
Pretty much so. I was trying to do them a favor.
And as part of that favor, you were going to allow some of the royalty from production from the proposed well to be paid to Murid or to Drummond or whoever the landowner is, right?
Exactly.
And this was all was this part of a negotiation to try to settle the well location dispute?
That's the way I understood it.
Okay. So there was no geology, no science that went into this necessarily. This was all a matter of land distribution, correct?
Right,
Okay.
right.
I have no further questions.
All right. I believe we gave opportunities for recross with some of the prior witnesses, so I will just offer Mr. Schlatter if you have anything additional.
No recross, Chair French.
Mr. Marsh?
No, Chair French.
All right. Very well then. We will conclude with this witness then. Mr. Brown, we appreciate your testimony. You may virtually step down, but feel free to stay where you are.
Okay.
All right, we've been going a little over an hour and a half, and we're coming up on our final witness, but I think it'd be good at this time to give everybody a brief break. So we will take let's see. Let's take a 13-minute break so we come back at 10:50. So we are now off the record and in recess until 10:50.
Okay, well, I'm following you.
And please go ahead and mute your microphones. Thank you. All right. I am showing 10:50 and it looks like we have everyone back with us. So we are now back on the record in this proceeding and we are ready for staff to call its witness.
Thank you, Chair French. Commission staff calls Jake Eastis.
Good morning, Mr. Eastis. Would you
Morning.
please raise your right hand for me? Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Please proceed, Mr. Marsh.
Thank you, Chair French. Please state your full name for the record.
Jake Eastis,
Jake, by whom and what capacity are you employed?
I'm employed by the Kansas Corporation Commission Conservation Division as a professional geologist and research analyst.
Are you the same Jake Eastis who caused to be filed in this docket testimony consisting of 8 pages on August 8th, 2025?
Yes.
Do you have any corrections to make to your testimony?
Yes, just one small one on page 4, line 20. I referenced paragraph 5 of the application as the brief explanation of the exception requested. This needs to be changed to reference paragraphs 6 and 7 instead.
Okay, thank you. Do you have any other changes to make to your testimony?
No.
Do you swear the answers contained in your pre-filed testimony are true to the best of your knowledge?
Yes.
And then one last question. In your testimony, you initially stated that you would like to review additional documentation before making a final recommendation. Based on the documentation that has been provided, do you have a final recommendation?
Yes, I recommend the commission grant the well location application for the drilling of the Drummond number 1, and I recommend it be signed a full allowable.
Thank you. At this time, staff moves for Mr. Jake Eastis's pre-filed testimony to be admitted into the formal record.
Any
Objection.
All right, hearing no objections, Mr. Eastis' testimony, reference testimony exhibits will be admitted.
Thank you. Staff tenders the witness for cross-examination.
All right. We will turn to applicant operator here first, Mr. Blatter.
Thank you, Chair French. I'll be very brief. Good morning, Jake.
Morning.
How are you today?
Good.
Good. I just had a couple quick questions for you. Page 6, lines 6 through 13, you'd requested that applicant furnish you logs and drill stem tests to support the drilling of the Drummond number 1 well. Did you receive those logs and drill stem tests?
Yes.
Did you have a chance to review the logs and the drill stem test?
Yes, I did.
Okay, and as a petroleum geologist with education experience in the field of petroleum geology, do you agree with Mr. Leese's evaluation of the reservoir characteristics likely to be encountered in the drilling of this Drummond number 1 well?
Yes, I do.
And do you believe drilling the well at that particular location is necessary to prevent waste?
Yes, I do, given the... Yes.
That's all I have for you, Mr. Eastis. Thank you.
All right, we will now turn to protesters. Mr. Rhodes, do you have cross-examination?
Thank you, Chair French. Mr. Eastis, were you in receipt of a letter that was delivered to Kelsey Marsh dated August 14th, 2025, and has been marked as protesters exhibit number 4, responding to your request for additional information stated in your pre-filed testimony?
Yes, I believe I received it. I had everything up to view, but I had to run to the office because the internet was terrible at my house. So I don't have it up currently right now.
Okay, but you do recall reviewing that letter?
Yes.
Okay. And did you have any objections to anything that was stated in that letter?
No. I mean, and I might have to pull it up to see which one it was. I mean, I didn't. I don't believe I had any objections. I didn't. I read the letter to gain an understanding of the situation.
Okay. And did you have any concerns about violation of correlative rights associated with the proposed location of the Drummond #1 well?
Did I have any concerns about the violation of correlative rights?
Correlative rights.
Yes. It appears that those had tried to be addressed between the applicant and the protester, and they had not been able to come to some sort of agreement. But from my, from my experience in reviewing numerous other well location exceptions and unitization applications, the applicant proposed the most fair and equitable outcome in regards to the forming of the standard 10-acre drilling unit in order to drill the Drummond #1 at a legal location.
Okay, and is that then the basis for your recommendation of approval of the application in this docket?
It's one of them.
What are the others?
The applicant they submitted everything necessary for approving well location exception. I agree with the applicant's geological interpretation. I also agree that there's a higher probability that oil will be found in greater economic quantities in the mist chert and mist lime at the location of the Drummond #1 as opposed to other locations in the vicinity. I further agree with the applicant that curtailing the production from these two Mississippian producing zones would in fact cause waste. Protesters' request for the release of the Brown lease and the new lease of the north half northeast quarter of Section 35 in regards to other well location exceptions that we have seen is unreasonable and unequitable given the present situation and circumstances.
Even though that suggestion of release of the north half of the northeast quarter was made in connection with an attempt to reach a compromise or a settlement in this matter?
Sorry, can you restate that?
Yes. You said you disagreed with the protesters' proposal for unitization in order to facilitate the drilling of the Drummond #1 well. Is that right?
With what they proposed and what has been shown here in the hearing today, yes, it was unreasonable and unequitable.
Okay. Do you disagree that drilling of the Drummond #1 well 100 feet from the protesters' property is a violation of the protesters' correlative rights?
Do I disagree
Yes.
that if it was drilled 100 feet away, it's a violation of the correlative rights?
Right.
I guess can you restate that question, I guess, in any sort of way?
Well, we're trying to reach a balance here, and we've got your testimony concerning the geologic considerations and so forth for the well location for the applicant's well. What we haven't discussed though is how the well location for the applicant's well could conceivably violate the protesters' correlative rights, being only 100 feet from their land.
I mean, we've talked about that already, the applicant and the protesters. I mean, it may or may not, given the geology of the target formations.
Yeah, I understand. I'm asking you for your opinion.
There's like, it's the same, that's been stated earlier. It's it may or may not. It's based off of the geology.
Are there other factors that lend support to your recommendation of approval of the application in this docket?
I've listed those 5, I believe, earlier. Those were those 5 reasons.
Okay. I have no further questions.
All right, thank you, Mr. Rhodes. This time we will turn to commission questions. Commissioner Keither, do you have any questions?
No, thank you.
All right. Good morning, Mr. Eastis.
Good morning.
Thank you. Thank you for being here today. I do have just a few questions, probably along some of the similar lines. You're a geologist. You've reviewed all the testimony. Are you in agreement with some of the testimony we heard from Mr. Lees along the lines that the drainage radius from this well would be 100 to 150 feet? So there is some possibility that there could be some drainage from the adjoining parcel?
Yes.
Okay.
I'm in agreement with that.
Are you also in agreement with some of the redirect that Mr. Schlatter performed, where I think the point was that if there is drainage, it's far enough away that he seemed to be indicating it would be maybe more of a de minimis amount that would come from there. Is there a basis for that, or is that just hard to know with the level of detail we have on the geologic maps?
It's hard to know. I mean, there's lots of factors that could go into it. You know, the geology is one, like the porosity and permeability that was discussed earlier. You know, the type of frac that could be put on it and what it's being fracked with, and just the, you know, general geology in a certain location. Basically, you don't know what you're going to get until the bit, you know, drills through it.
Okay. So is this a case where staff would have preferred that the parties came up with an application for a unitization plan that seemed reasonable, as opposed to this application, which it kind of seems like an all or nothing?
Correct. Yes. And if they would have come together for some type of, you know, that standard 10-acre oil drilling unit would have been more reasonable for all involved. That's what we typically see in these well location exceptions.
I think I caught all that, Mr. Eastis. I don't know if you're a little far from your microphone, or maybe it's just my audio was cutting out a little bit.
I was saying that the standard 10-acre oil drilling unit is what we typically see to alleviate these issues whenever a well location exception is needed.
Okay. I asked Mr. Brown this, and I think I got a pretty clear answer, but we've seen the applicant's Exhibit A, where essentially it's the square that lays out the protesters' sort of proposed settlement offer, their proposed unitization configuration. And I think they indicated, no, that was just a negotiation. There's no geological basis for that unitization configuration. Would that be your assessment as well?
But there's no geological.
Yeah, or production, that wouldn't necessarily follow where you would believe the production would occur.
No, I mean it those lines that were drawn, the one that was 430 foot north of the south line and 900, or I think it was 900 and some south of the north line. That one.
Yes.
No, I mean that one, that was, I don't know, I guess in my opinion, it was very odd that it was drawn that way.
And in your opinion, that would not be an equitable division.
No.
Final thought here, because there is testimony that the 150 feet is potentially problematic, or the 100 feet is potentially problematic. And I asked operator about the possibilities of, was there somewhere more, maybe closer to 150 feet, would there be somewhere on their property that would also be an acceptable location? And, I know their position is this is the spot we picked. Did staff perform any independent analysis of the geologic maps to determine if there would be any other reasonable spot that might get us away from that 150-foot drainage radius that would also be reasonable?
The analysis I did was to check the formation tops on the map and just to make sure that yes, these were all correct in creating that map in Mr. Lee's exhibits. I mean, not the map, the maps in Mr. Lee's exhibits. And I mean, I came to the same conclusion that is most likely the best location, given the geologic interpretation with the data that's available.
Okay. So there's not another spot that's sort of a close second, but it would get us out of that 150 feet. This clearly was the best spot.
I mean, given the situation with, the previous production and the nature of the formation, with the porosity and permeability that has been talked about, I mean, that is, probably the best location for success. Yeah, success is in, producing the greatest quantities of oil,
Is the formation that touchy that you couldn't move 10 feet north, or I mean, obviously the idea is they don't want to move 50 feet north, even though I'm a non-geologist, but 50 feet to the north doesn't seem like a lot. You know, is the formation that touchy that you can't move 10, 25, 50 feet?
I mean, it's, consider what we call tight. And, with those wells on the mirror, at least to the north, that have already drilled and have, that have already been drilled and are producing from the Mississippi Chert, and the wells to the south on the Brown lease that have been drilled and completed the Mississippi Chert. The most advantageous spot would be in, that equidistance in between those four wells. And you would, you could possibly see, a difference in production, just with that 50 feet to change, given that with those other previous wells drilled in that, basically those locations already.
So I guess let me ask you the $550,000 question here. In your opinion, does the risk of correlative harm to correlative rights within that 150 feet drainage radius, is that outweighed by the potential for waste if we were to move back to start moving around the well location?
I mean, it's kind of hard to say that. I mean, that's like you said, the $550,000 question. I mean, if you did move it, you would just get that producing interval, and then it could possibly always be on your mind, like, well, if it was 50 feet the other way, maybe it would have been higher, or vice versa. So it's kind of hard to answer that question.
Yeah.
To say, like, would this, outweigh that the court of rights issue? I know that's not really the answer.
It's not super satisfying.
No.
That seems like that's the question we're being asked to answer here. I think the question we're being asked here is that threat to correlative rights, is it essentially de minimis, as I believe operator has suggested, and the threat to waste is very high if we don't allow the application. That seems to be applicant's position. Does staff agree with that?
I would agree with that, yes.
Okay. All right. I don't think I have anything else then. Let's see, where are we? Okay, we are ready for redirect. So, Mr. Marsh, do you have any redirect for this witness?
I do not, Chair French.
Any need from recross by either of the parties?
None from
No,
applicant.
no, Chair.
Okay, thank you very much. All right. Well, then with that, Mr. Eustis, we do thank you for your testimony, and you may virtually step down.
Thanks.
Let me get back to my script here, and I believe we are ready for closing statements. Now that we have concluded with all our witnesses, we will start with staff, and just so everybody knows, for order, we'll start with staff, then we'll move to protesters, and we will let the applicant conclude. So, staff, if you want to begin with your closing statement.
Thank you, Chair French. As I indicated in my opening statement, staff recommends the commission approve the application at issue in this matter and grant the proposed well a full allowable, since the application complies with all requirements under KAR 82-3-108, prevents waste, and should have little impact to correlative rights. Thank you.
Thank you, Mr. Marsh. Protester, Mr. Rhodes.
Thank you, Chair. KAR 82-3-108 assumes that a well drilled closer than 330 feet to a leaser unit boundary is going to violate correlative rights and potentially cause waste. And we have a location that's been applied for here that's only 100 feet away from the boundary of the protester's land, and the presumption is that it's going to violate their correlative rights. And the applicant's got the burden of proving that it will not, and they have not prevailed in meeting that burden of proof. So the protester's position it hasn't changed. There's no reason for the applicants not to drill on the protester's land on the Brown lease. There's no reason for the protesters or for the applicant to drill 100 feet away from the protester's land, even though it might meet certain geologic conditions. It's still going to result in violation of protesters' correlative rights, which is the purpose and the objective of 82-3-108. So instead of preventing waste and protecting correlative rights, the proposed well location that's advocated by the applicant in this case is going to result in waste that by drilling a well that could be located on a protester's land and violates protesters' correlative rights and should therefore be denied.
All right, thank you, Mr. Rhodes. And finally, Mr. Schlatter for applicant.
Thank you, Chair French. I'd like to touch on what Mr. Rhodes just said about operators' burden to prove that granting this exception will not violate correlative rights. That is legally incorrect. In Mr. Eastis's testimony, the regulation at issue is, I believe, copied. It'll be at page 3, lines 22 to page 4, lines 4. And in no uncertain terms, that says a well location exception may be granted to permit drilling within those shorter distances, being 330 feet, if these exceptions are necessary either to prevent waste. There is no dispute that this well is necessary to prevent waste, either to prevent waste or to protect correlative rights. And I think that word protect is important in this particular application. So operators established that, and staff has corroborated that drilling this well is necessary to prevent waste. We heard no testimony to the contrary. As far as correlative rights goes, that word protect means is sort of like a shield. You use a shield to protect yourself. The protester seeks to use his correlative rights as a sword, as something to assault both Mr. Drummond's correlative rights and the correlative rights of the working interest owners on either side of the lease, who have all agreed that this well should be drilled at this particular location. The protester was given the opportunity to have his correlative rights protected through the formation of a unit. As he stated, he doesn't share. Well, that's not fair to anybody else, and instead use this as an opportunity to demand that Darrah Oil forfeit what, as shown in Exhibit A, approximately 60 acres of leasehold rights that it now controls, and to take 2/3 of the royalty from his neighbor on a well drilled on his neighbor's land, which is directly contrary to his own family policy. I don't think those are proper grounds to oppose an application, and they certainly aren't grounds to defeat one. And for that reason, I believe the application should be granted with the location at the distance provided, and a full allowable will be granted as well. Full production allowable. That's all I have.
All right, thank you all. With that, move to some post-hearing issues. Before we conclude, did the parties discuss whether there was any need for post-hearing briefing in this proceeding?
We did, and there was a consensus that there would not be.
Okay. Has that changed based on anything today?
No, I don't think so, Mr. Chair.
No, Chair French.
Very well. Any other issues the parties wish us to address before we conclude?
I had one, Chair French, during Mr. Brown's examination, Mr. Rhodes requested the opportunity to file rebuttal exhibits of some sort. My client's been working on this project for going on a year now. I'm wondering if we can put a fairly quick timetable on that. I don't know how long the transcript takes anymore these days, but something inside of that, so we can get an order out as quickly as possible.
Yeah, I think he knows what exhibits you had, and the transcript should probably be 10 days. But I would say if there's going to be a motion for any additional exhibits, let's try to do that within 14 days. I mean, I think you ought to be, Mr. Rhodes, you ought to be able to identify anything that was responsive to the trial exhibits within that time frame. So obviously your call on whether to file a motion or not, but if there's going to be a motion for late filed exhibits, let's do it within 14 days from today's date.
No, we should know quickly whether a motion is going to be necessary, and if so, we can file it certainly as expeditiously as possible, probably before the transcript's done.
That would be very helpful. I don't think that would impact the timing of a final order either way. Of course, not knowing what your exhibits may be, but 14 days I think would work for everyone. All right. Any other final matters? All right, hearing none, this does conclude the hearing in this proceeding. And at this time, we will close the record and adjourn. Thank you all for your time and participation in the hearing this morning.
Thank you, sir.
Thank you.